And even if your ladyship were to find that it sinks my case in respect of the specialist consultant's report, in respect of the consultation, in respect of the mapping requirements, what it cannot sink is the clear evidence that they came with the complete misunderstanding as to what their function was, the heritage assessors, as to what their function was in terms of both the National Heritage Resources Act and the environmental impact regulations. That's as far as I can take it, lady. Lady, if we can then move on. So we make the submission on that basis that the decisions of the fourth and fifth respondents are reviewable on the basis of at least two of the review grounds relied on in the founding affidavit. Section 6.2b of PUDGE, and that a mandatory and material procedural condition prescribed by an empowering provision was not complied with. More particularly, there was non-compliance with both the first and second parts of the proviso in Section 38.8 of the NHRA, read with Section 38.3, and then Section 6.2f2bb of PUDGE, in that the decisions of the fourth and fifth respondent were not rationally connected to the purpose of the empowering provision, Section 38.8, read with Section 38.3, which are designed to ensure that cultural rights and heritage resources and the impact on them of developments are properly factored into the decision-making processes pertaining to developments. And we point out that on the same facts, additional review grounds in Section 6.2 of PUDGE would become available upon supplementation in terms of Rule 53.4. But the basic point is under a PUDGE umbrella, it's a legality challenge. That's the thrust of it. On the basis of the foregoing analysis, the applicants have demonstrated the requisite prima facie right, and they have done so at a level that is at the very least at the strong end of the spectrum, a topic to be discussed later in argument. If the NEMA decisions are set aside, the construction is unlawful. This is so regardless of the validity or otherwise of the land use planning decisions. I deal very briefly with the land use planning decisions. We concede that the identification of the review grounds in respect of the land use planning decisions is still in the process of formulation. But we make the point here that the minister relies extensively, sorry, I beg your pardon, the mayor relies extensively on the First Nations report or the UFMAS report. We say that it's non-compliant with the statutory provisions relating to what is required of a consultation, and what will certainly be introduced into the review grounds in the Rule 53.4 supplementary affidavit is the fact that the invalidity of Mr. Orence's process will then impact upon the municipal decision-making process that relied on it. But in any event, to establish a strong prima facie right, it's sufficient that we target the provincial decision-making, because once that authority is gone, there is no longer a basis for the construction to proceed. Then at page 54, move on to the Shell case. That is a recent judgment of the Eastern Cape Division. It's in your ladyship's bundle of authorities, but I quote all of the relevant parts of the judgment in these notes. We say that the matter provides considerable support for the grant of the relief sought by the applicants in the present matter. As is reasonably well known, the matter concerned the conduct by Shell of a seismic survey using air guns fired from a ship off the Wild Coast in the Eastern Cape. The applicants were in the main members of traditional communities living along the coast, including traditional healers from those communities. The seismic survey was to be conducted pursuant to the grant of an exploration right by the Petroleum Agency of South Africa in terms of Section 79 of the Mineral and Petroleum Resources Development Act No. 28 of 2002. The purpose of the seismic survey was to provide imaging of the subsurface to determine whether there might be energy reserves below the seafloor. Applicants sought an interim interdict in Part A of the Notice of Motion, preventing the relevant respondents from proceeding with the seismic survey, pending the grant in terms of Part B of a final interdict, prohibiting the respondents from proceeding with the survey unless and until they had an environmental authorization under NEMA. Also in support of their claim for interim relief, they raised the failure to meaningfully consult with them in relation to the seismic survey because it impacted on their customary, environmental and cultural rights in terms of sections 24, 30 and 31 of the Constitution. Applicants relied on the judgment of the Concourt in Bengwenyama, where the Constitutional Court held that consultation, in that case under the MPRDA, included amongst its purposes not just the full provision of information about the activity consulted on, but also recognition that the consultation process and its results are an integral part of the fairness process. And that although the achievement of consensus was not required, the consulting party should consult with the view to reaching agreement to the satisfaction of both parties in regard to the impact of the proposed prospecting operation. The applicants made extensive references to their rights to intangible heritage and culture associated with the sea. The deponents to the applicant's founding affidavit said that they adopt the attitude that not only does the land belong to them, but they also belong to the land. That is so because the land is central to their identity. It sustains them. Another deponent referred to their practice of walking to the sea to collect its healing waters and sacred sand. Paragraph 14 of the judgment records members of the Amadiba Traditional Authority also know the sea and the land to have healing properties. In some instances, traditional healers rely on the sea, for example, to cleanse themselves and their patients. Some of the ancestors reside in the sea because they loved the sea in life, and some of them died in the sea. It is considered very important by members of the Amadiba Traditional Authority not to disturb these ancestors through pollution or other disturbances. That belief should not be difficult to comprehend by those who do not share the customs of the Amadiba Traditional Authority, if regard is had to the fact that graves on land are not easily disturbed or moved. Members of the Amadiba Traditional community are concerned that the seismic survey will upset their ancestors and impact on their cultural and spiritual relationship with the sea. They are concerned that Shell did not consult them in that regard. They also claim that because it is integral to the community's cultural identity and customary system, in other words, the sea is integral to who they are, they have over time developed sustainable fishing practices which pose no great risk for the marine life. They also relied on the ocean for sustainable harvesting of seafood. Insofar as consultation was concerned, Shell insisted that it had not only followed but exceeded all requirements for public participation. Their database of interested and affected parties included a wide array of provincial and local authorities, traditional leaders, NGOs, community-based organizations, and industry groups, including the fishing industry. Public notice had been given in newspapers of the public participation process. The applicants insisted that they, as coastal communities, were not amongst those consulted. To the extent that public meetings had been held, this had been a long way from where they lived. Shell insisted that they consulted with their traditional leaders. The applicants rejected this as being inconsistent with their custom. In this regard, the court held Shell did not identify the numerous small-scale and subsistence fishing communities along the coastline where the seismic survey will be performed. Regard being had to the above, the consultation process was, in my view, inadequate. He then quotes the Makoma judgment. I won't read that out. In response to the assertion of their intangible heritage and cultural rights, the court held as follows. I accept that the customary practices and spiritual relationship that the applicant communities have with the sea may be foreign to some and therefore difficult to comprehend. How can ancestors reside in the sea, and how can they be disturbed, may be asked. It is not the duty of this court to seek answers to those questions. We must accept that those practices and beliefs exist. What this case is about is to show that had Shell consulted with the applicant communities, it would have been informed about those practices and beliefs and would then have considered with the applicant communities the measures to be taken to mitigate against the possible infringement of those practices and beliefs. In terms of the Constitution, those practices and beliefs must be respected. And where conduct offends those practices and beliefs and impacts negatively on the environment, the court has a duty to step in and protect those who are offended and the environment. Also of significance to the present matter is that the applicants had not yet refined their Part B relief. They still intended amending the relief sought under Part B to add a prayer reviewing and setting aside the exploration right, which had not been reviewed in the initial notice of motion. There was also doubt about the validity of their contention as to the need for an environmental authorization at ANEMA, the Minister having filed an affidavit suggesting that the approved environmental management program used to support the original application for an exploration right was statutorily deemed to constitute an environmental authorization. In this regard, the learned judge said, whether that is so, however, is a decision to be made by the court. Although I'm of the view that the applicants have prospects of success in that regard, it is a matter that should rather be considered by the court, which will determine the relief sought under Part B of the notice of motion. In dealing with the question of irreparable harm, the court identified the harm as follows. The applicants rely on cultural and spiritual harm. The threatened harm to marine life and the negative impact on the livelihood of small-scale fishers arising from the harm to marine life. I've already dealt with the impact that the seismic survey will have on the applicant community's cultural and spiritual beliefs. To conclude the discussion on this topic, reference is made to the evidence of, and he then describes who she is. The material basis of the Dwesa Curiae ocean coastal culture comprises three elements: sense of place linked to their coastline, a relational ontology linking them to their ancestors, and the way meaning is substantiated through socio-ecological interactions, performing rituals in the sea providing sustenance through fishing and harvesting activities, thus including both tangible and intangible culture. This is very evident in Dwesa Curiae community's coastal land ocean culture today. The court was willing to accept that, that this, along with the considerable expert evidence regarding the harm to marine life, was sufficient to satisfy the requirement of irreparable harm. The court then turned to the question of the balance of convenience. Paragraph 66, I will now consider the balance of convenience. To make a finding in that regard, the court must balance the harm that the applicant will suffer if the interim interdict is granted against the harm that Shell will suffer if the interim interdict is granted. The balance of convenience is not evaluated in isolation. The stronger the prospects of success in the main proceedings, the less the need for the balance to favour the applicants and vice versa. Shell contended that the balance of convenience very much favoured the refusal of relief because it would suffer prejudice that was real and devastating if the interim interdict against it could be granted, whereas the prejudice that the applicants would suffer if the interim interdict would not be granted is speculative. Shell's case is that if the interim interdict is granted, it will be final in effect because it will make it impossible for the survey to complete it by the end of May 2022, that Shell and Impact Africa will be able to exploit the exploration rights, and that the termination of the survey will result in an immediate cost of approximately 350 million rand to Shell and Impact Africa, with an estimated total loss as a result of having to terminate the survey and subsequent loss of exploration rights exceeding 1 billion rand. They described the potential harm to them as catastrophic. These considerations did not, however, win the day. The court held as follows. Shell should not be allowed to use the consequences of its own failure to adequately consult with all interested and affected persons as a ground for why an interim interdict should not be granted against it. Constitutional rights are at stake. The financial loss that Shell and Impact Africa are likely to suffer cannot be weighed against the infringement of the constitutional rights in question. Put differently, the anticipated financial loss to Shell and Impact Africa cannot justify the infringement of the applicant's constitutional rights. The breach of those constitutional rights threatened the livelihoods and well-being of the applicant communities, as well as their cultural practices and spiritual beliefs. Where constitutional rights are an issue, the balance of convenience favours the protection of those rights. In my view, the applicants have established that the balance of convenience favours them. In relation to the question whether or not there was an alternative remedy, Shell referred to an administrative remedy involving an approach to the minister to cancel or suspend an exploration right. In this regard, the court said, it is obvious that the section envisages a time-consuming procedure which, if followed, would allow the continuous threat of infringement of the applicant's rights. Although the above section does provide a remedy, it is in the circumstances of this case not a satisfactory remedy. The question of urgency was also raised. Shell adopted the attitude that the applicants had failed to show why they would not obtain redress at a hearing under Part B in due course. It was also pointed out that the applicants could have acted earlier and have intervened as parties in a prior application where similar relief had unsuccessfully been sought against Shell in respect of the same seismic survey. In this regard, the court held as follows. On 8 December 2021, Shell requested a case flow meeting for a more reasonable timetable than the one contained in the notice of motion. On that same day, I presided over that meeting. The parties agreed on the date of the hearing as well as the dates for the delivery of the affidavits. It's correct that the application must have caused severe inconvenience to Shell and its legal representatives, particularly this time of year. However, when regard is had to the steps taken by the applicants after they became aware of the commencement of the seismic survey, the issues raised in the application, here referring to the fact that there was a threat of infringement to constitutional rights and the rule of law, that Shell had, under the circumstances, sufficient time to put its case before the court as well as the public interest in the outcome of this application. I decided to exercise my discretion in favour of the applicants and dispense with the rules insofar as they regulate the periods when documents should be delivered. The circumstances, the court granted the application and ordered Shell and the minister to pay costs. Significance of this judgment in respect to the balance of the requirements for an interim interdict will be dealt with below. However, it is appropriate at this stage to point out, firstly, the fact that Part B relief was still to be further refined, potentially introducing an entirely new review application in respect to the exploration right, did not preclude the grant of the interdict. This is relevant to the fact that the applicants are still in the process of refining their review grants as against the city and the mayor. The judgment conveys powerfully the truism that the fact that the heritage and cultural rights may be intangible is no obstacle to the grant of an interim interdict where they can be shown to be linked to physical phenomena such as land and the sea and fall under the cultural rights in section 30 and 31, and this is so even in the face of the most powerful economic interests. Thirdly, the courts take consultation seriously, a process that excludes a small but important section of society whose cultural and spiritual rights are threatened will not be accepted as passing constitutional muster, nor can such a section of society be dictated to as to the organizational structure through which they should be consulted. Then, lady, we move on to the question of irreparable harm.
Can you just pause for a moment? The extracts from the Shell matter, would it be on all fours with this particular case?
Well,
in terms of consultation, in terms of the intangible, I'm specifically referring to the intangible heritage resources, would it be on all fours with this matter?
Well, the first area where it's not on all fours as in this matter is that the prima facie right in this matter is a lot stronger than the prima facie right was in the Shell matter. So certainly not on that score. Obviously, it involved the sea as opposed to, it was a different factual scenario. But there is
So you would say that the rivers, that in this instance, the significance of the rivers would be
there's an overlap
on
between.
par with the significance of the sea.
Indeed, milady, and it's not just the rivers. They talk about the land as well.
Yes.
So they live on the land next to the sea. It's the combination of the two.
And those rituals refer to, or the intangible heritage resource referred to in Shell, is it something that was utilized by the community? Because in the instance of the two rivers, it appears as if it was just a golf course and nothing much happened there. No one had access to it. No rituals could be performed, etc., etc.
Well,
I'm just establishing where they meet and where they.
And your ladyship is quite correct. If we look at Transkei's history, people's property rights were respected to a substantial degree, and that's why they've been there for hundreds and hundreds of years. They had that protection under the system of
Sorry,
colonialism.
I missed the first part of your argument. What are you referring to now? Whose property rights?
So you as I understood it, you were contrasting.
Yes, I was.
The fact that
I wanted to.
we're sitting here with a golf course which isn't occupied by my clients. We're sitting there with land next to the sea which is occupied by their clients.
Yes.
With respect, yes, I immediately concede that's a difference
I
between the two
suppose that
cases.
would be the nature of an intangible heritage resource. You don't necessarily, the fact that they don't go there does not
Indeed.
mean it does not exist.
Indeed, milady.
Yeah.
And there's the practical difference here, which is that because of colonialism and apartheid, First Nation people have been violently removed from that land. Fortunately, in Transkei, that hasn't happened. But it doesn't mean that they don't retain the same intangible
Yes.
cultural rights in respect of those two pieces
So
of
it
land.
could be on all fours with regard to tangible and intangible heritage resource. But,
And it's on all
oh, then the
fours.
second point, sorry, I just lost my thought. The second issue that I wanted to raise, the consultation process in Shell, did it completely exclude certain groups?
Well,
I've noted the comparisons, and it appears as if the consultation process was an important consideration in Shell. So what happened here, would it be on all fours with this case in terms of the consultation process?
It wouldn't be on all fours because this was a unique case under a particular section where a person was specifically instructed to conduct a particular
Yes.
process. So I would submit that here it's in a way subject to even closer scrutiny because we can pinpoint so closely the section that wasn't complied with, which is 38.3e. The position there was that, in fact, Shell had consulted very, very widely. They had a massive stakeholder base. And my understanding is that their claim was in respect to communities like these ones, they'd spoken to their traditional leaders. The community said, we don't accept that as a valid form of communication. You should have spoken to us. They also complained that some of the public meetings had been held some distance away. Shell complained that there'd be notices in newspapers and so on, that people had the opportunity to come forward and make their comments, and they hadn't done that. But the court said, no, you need to go and find all of those little communities, and you need to talk to them. And we say that was possible here. We've, with respect, given your ladyship the list of people who were excluded from the process, we say, and it was possible to find them and talk to them, each and every one of them, without forcing them to come into a particular formation to be able to do that.
And in the Shell matter, were there indications of different views held by different interested parties, such as in this case, where you have one group of the First Nations who support the development and another group who does not support the development?
That information isn't apparent, save to the extent that one can infer it from the fact that the traditional leaders who they'd spoken to were seemingly, they certainly hadn't brought a case to stop.
There was consensus there.
So I can't take it that far, my lady, but all we do know is that Shell said we satisfactorily consulted with your traditional leaders. I don't have any further information beyond that. It's not apparent from the judgment.
We're moving to the next point. Where are we now? Balance of convenience.
So we've got irreparable harm,
Yes.
we've got balance of convenience, and then we have no adequate alternative remedy, which is short. We've got, and then we've got the strikeout applications, and we've also got urgency to deal with at some point as well. Urgency, I think we've substantially
Yes, we
debated,
have.
my lady, and what I've written here is what I've written here. I don't think I need to go back there. If necessary, I can come back to it and reply. I think for the strikeout applications, it may be appropriate that I deal with the strikeout applications in reply. The respondents have got the benefit of what our written submissions are in respect to the strikeout cases. I've given them the authorities at some length that we rely on, and I think I can. So I think it leaves irreparable harm, balance of convenience, and I would like to spend some time dealing with the Camps Bay Residents and Ratepayers Association case. So I'm not sure how your ladyship would wish to proceed in the circumstances. I can get through this reasonably quickly, but I'm also very mindful of snuffing out Mr. Bishop. If I'm going to snuff out Mr. Bishop, then it might be that I must sit down and say, rest with our written submissions.
Sorry, I didn't consider Advocate Bishop at all now. I wanted to suggest that you continue. I would really leave it to the parties. But on the balance of convenience, do you have any submissions, anything that you'd like
Lady,
to It appears as if this is an extensive project, and when I consider the city's position, they're saying, look, we support this project and it will generate some income, economic activity, or economic benefits for the city. Project provides for low-cost housing, and of course the fact that the project actually started already. More importantly, I think I should first pose that question, the fact that the project already started, it's out of its starting blocks. Will that impact on the question of balance of convenience?
Well, lady, we say that was something that the developer took on entirely at their own risk. They took big risks in this case. This was always a contentious case. There was big public opposition to it. This challenge was coming at them like a freight train. And despite the freight train, they decided to bash on with construction, and they must deal with the consequences of.
Yes, the other issue that the city also raised was this bridge that was going to be built, and so it's the infrastructure benefit, economic benefit, low-cost housing, rehabilitation of the rivers, and of course the fact that the project, there were conditions attached to the project. I think they also must pay 71 million rand to the city. When I look at all those things, I'm actually more interested in the fact that the project started, but the applicant's submission in that regard is that the respondent commenced at its own risk.
Inter alia, right? There are a lot of submissions that are contained.
So that would become a neutral factor.
That's one of the factors that
yes,
needs
but I'm
to be
saying
taken into account.
if the court accepts that it was clear that there was going to be opposition to the project, yet they decided to proceed. So what the applicant is saying is the court should not be moved by the fact that it proceeded because they knew exactly what the state
What they
of
were
play
letting
was
themselves
at
in
the
for.
time, and that the project was being vigorously opposed.
Indeed, my lady.
Yeah.
Indeed. And there's the correspondence. They knew of the resolution that they keep referring to that said that this was coming from.
But that resolution was actually taken quite early already. It's a 2020 resolution.
Indeed, my lady. And there were the letters of May, July. I think there were 3 letters. There was another letter sent shortly before Christmas.
And they were also asked to stop the project, but the first applicant was not amenable to that request.
They weren't at all amenable to any of that. And there was also a letter that suggested agreeing to, if they gave an undertaking, there would be a timetable. That offer was rejected. That was contained in one of the letters. So
I'm just giving you the opportunity to deal with, if there's anything else, I'm just engaging you on that.
Can I say this in relation, 2 things in relation to the balance of convenience? And perhaps if I could start by just referring to the Camps Bay Residents and Ratepayers Association case. There's also irreparable harm, lady. I commend to you the written submissions where we
Yes.
quote extensively from what Mr. Jenkins says about irreparable harm. And again, this is where the Shell judgment is extremely helpful and really on this aspect on all fours. We who are not amongst First Nation peoples might have difficulty getting our heads around this notion of the universe consisting of us, the land, nature, and being tied as one. And that violations to those are really violations essentially to the body. What the Shell judgment says is the fact that we non-First Nation people can't get our heads around that is not a reason to not take it very, very seriously. And if one looks at what Mr. Jenkins says about those issues, one looks at his description of the area as the epicenter of the resistance to the colonial forces and how that's become embedded in their memories. The pouring of concrete into that area is a very, very harmful act. And it's aggravated by the continuing construction. I mean, at the moment, I think it's a portion of the site. There's still a significant portion of the site that remains undeveloped. But every bit of concrete that's poured in there is deeply problematic to them. If one looks at that diagram that I referred your ladyship to earlier, at the confluence, which everybody seems to accept, is sacred. In fact, I read something in the Daily Maverick the other day by somebody who wasn't a First Nations person who spoke about the sacred nature of river confluences. There are 2 10-story buildings that are going to go up there. They aren't there yet. So there is certainly an big advantage in granting the interim interdict and preventing it from happening.
So if the court should come to the assistance of the applicants, what would the further conduct be with regard to the site, more specifically in view of the fact that they commenced construction work there? What could the further conduct be? Could it be a low-density development?
Well,
I'm posing the question.
No,
I need to consider that.
I hear your ladyship.
Or
at least
even no development if it's declared a World Heritage Site or provincial,
that's obviously
national.
what is aimed at. And obviously in the final relief, we will seek to get the concrete out. Mm-hmm. But at least if it's stopped now where it is, at the moment, I think it's round about a few stories high, as I understand it, where he says the Khoi and the San have the most exquisite symbiotic relationship with the soil, with the river, with the stars, with Ikachin, who's the mantis. And when you look at the Lesbiak River, the flow of that river and the land next to it, when I talk about a symbiotic relationship, I'm saying that the river is flowing within, it's embodied within the consciousness of the Khoi, and so is the land. You can't separate the two. So when you separate the Khoi from the land permanently, you separate a part of the body itself. It's disembodying the physical body, the physical manifestation that's imbibed in them. By dislocating the Khoi permanently from the land and from its proximity to the river, you're ripping the soul out of them. It was physical, visceral dislocation because of the understanding, the integral understanding of connectivity.
And that would tie in with this concept of intangible heritage resource status.
Indeed,
Yeah.
lady, and the inseparable link between
Yeah.
the land and the water and the intangible heritage.
Yes, and one should appreciate those aspects of
Indeed,
the
ma'am.
significance of
Indeed,
the
and the Shell
project.
judgment tells us we've got to respect that, and the Constitution, frankly, tells us we must respect that, and the National Heritage Resources Act tells us that we must respect that. So,
And this project will cause great harm to the intangible heritage
indeed,
resource, perhaps more to the intangible heritage resource than the tangible heritage.
I think they would say the two are inseparable.
Yeah, probably.
The one goes
Yeah.
the one goes with
It
the
is
other.
probably connected, interconnected. Should we give Advocate Bishop an opportunity now? And
So
then,
if I
then
could
you
just-
can always address the court at a later
If I can
stage.
just ask the court to have regard to it'll take me 2 minutes, two
Yes.
things. The one is, our primary submission is, and I know we've debated the issues all day, but we say we have a very strong prima facie right. There's Olympic Passenger Service judgment of Holmes J that says, and everybody agrees with it on their heads, strong prima facie right, balance of convenience plays less role. We rely on that. And we commend to you our summary, and I won't go through it, the Camps Bay Residents and Ratepayers judgment of His Lordship, Mr. Justice Law in this division, in which he very helpfully looks at all of the judgments from this division on stopping building and sets out exactly what the provision is and emphasizes the fact that the rule of law is very, very important. And he makes the point that the problem with allowing a construction to proceed is that the person builds themselves, the developer builds themselves into an impregnable position, which then causes bias in relation to the subsequent decision making.
But the court is alive to the arguments raised by the applicant that the respondents knew it
Indeed,
was a contested, highly contested territory.
Indeed, lady.
So the applicant probably prefers an approach to be adopted by the court that is an important, if not a neutral factor, important factor to
Supports
consider
the
that they knew
applicants.
it was contested territory.
We
And at the
submit-
minimum, the court should then regard it as a neutral factor. If not important, at least it must be neutral in the determination of the respective interests of both parties.
Certainly, we would think it would support the
Yeah,
applicants.
the applicants wouldn't want it to be regarded as a neutral factor, probably it remains important to the applicant.
As the court
Yeah.
pleases.